Senate Judiciary is back in session. We're going to now go to HB 1633. The Honorable Erica Leon is going to introduce legislation. Good afternoon. Sorry to keep you so late.
Good evening.
1633. The Honorable Erica Leon is going to introduce legislation. Good afternoon. Senate Judiciary is back in session. We're going to now go to HB 1633. The Honorable Erica Leon is going to introduce legislation. Good afternoon. Sorry to keep you so late.
Good evening. You've been doing good work today, so that's something we have to do is wait. For the record, my name is Erica Leon. I represent the town of Derry, which is Rockingham 13, and I am a co-sponsor of this bill. This bill should not be necessary, but it is, because the fiscal note shows that as many as 3 people a day who have been sexually assaulted in New Hampshire are denied a rape kit. This bill does not expand the definition of rape or sexual assault. RSA 21M19 states that the Attorney General shall provide written notice of the right not to be charged fees or otherwise prevented from pursuing a sexual assault evidence collection kit, among other rights. That reads about as clear as can be, yet this bill exists because a woman was drugged and groped before she was able to lock herself away from her attacker, who told her that he didn't mind that she was vomiting. It wouldn't stop him. She knew the law, she knew her rights, and she was denied her right to blood evidence of the drugging in the attempt of the sexual assault. Sexual contact when the actor, without prior knowledge or consent of the victim, administers or has knowledge of another person administering to the victim any intoxicating substance which mentally incapacitates the victim is a Class A misdemeanor under RSA 632A4(1)A. And this is sexual assault, according to the definition in RSA 742(4). This woman, who was drugged by a man who intended to rape her, is not a meek or quiet person. She is a person who speaks up loudly for her rights and the rights of others, and one who is able to cite the specific RSAs that granted her the ability to have a rape kit under New Hampshire law. Yet she was denied. That's why she's the prime sponsor of this bill. I co-sponsored this bill because when I heard it before the House Health and Human Services Committee, it became clear that there was a disconnect between the law on paper and the law in practice. This bill aims to close that gap. I'm aware of the current 1-page information sheet on the DOJ website, as well as the 40-page pamphlet produced in 2020. I'm also aware of a 2006 report from the Coalition on the Status of Adult Female Sexual Assault Victims that found that most of these crimes are not prosecuted. We haven't come far enough in 20 years. I'm aware of the testimony of the need for timely arrival to the hospital to get care and gather evidence, but the published information demonstrates none of this urgency. The pamphlet draws a line between being able to collect evidence or not at 5 days after a crime has occurred. That is 4 days too late for blood evidence if you've been drugged. I'm aware that rape kits come prepackaged at a cost of about $46 each, and that the processing of blood and urine samples cost about $500 each. That's how you tell if somebody was drugged. If a victim gets a kit with both blood and urine evidence, this costs the state around $1,000. I'm aware that during the previous session, I accessed a 300-page document provided by the Department of Justice for doctors to understand the process of conducting these tests. I was having trouble finding it on their website now. I'm not sure how a doctor would find that, read through that, and put it into practice. And I've heard it argued that currently medical providers determine whether the use of an evidence collection kit is warranted based on the information provided by the victims during the medical examination and scientifically based best practice forensic guidelines. Do we expect these doctors to make themselves intimately acquainted with this 300-page document and keep this front of mind during the fortunately rare encounters they have with sexual assault victims? Or should they have a handy guide that helps them know the timeframes and when they can collect evidence to help these victims reclaim their autonomy? Looking at the documentation in the sexual assault kit, blood evidence for drug-facilitated sexual assault must happen within 24 hours of the assault. And it's better if it happens sooner, since some drugs have a shorter half-life. Urine evidence for the same must happen within 120 hours. Touch DNA and foreign objects must be collected within 96 hours, and swabs of other regions must occur within 24, 96, and 120 hours based on the location. The current pamphlet says you have 5 days. We could do better. The state should do better. I would recommend that the Department of Justice revamp their notification of rights to urge sexual assault survivors to proceed directly to the hospital after an assault, to inform them that it is best to stay in their clothes and not shower, but if they had to clean up, they should still go to the hospital and get care and collect what evidence they can. Doctors should be given an information sheet on what is sexual assault and what the timeframes are for evidence so that they can just look at it and know instead of just telling a person no. I've had an interesting life, and one of the highlights was meeting prosecutor Carol Nelson with my Girl Scout troop. In 1988, she convinced Justice Storch as to the admissibility of DNA evidence, and her work actually led to the acceptance of DNA evidence in California. When available, forensic data can assist in convictions or clear a person's name. Evidence collected at one point in time can become far more useful when the science advances, and we can use newer technologies to get more information out of an old sample, even if it is degraded. While every kit used may not result in usable evidence, it does put the survivor back in the driver's seat by allowing them to take positive action to reclaim their body and their autonomy. I am very concerned that the fiscal note assumes that notifying sexual assault survivors of their rights will lead to the use of an additional 1,000 kits a year. That means there's approximately 3 people a day who currently do not have access to a rape kit that the Department of Justice believes will get a kit if this law passes. All this does is restate clearly what their rights already are. These unreported or under-recognized rapes come at a far greater cost than $1,000 each. When I was drugged and raped in college some 25 years ago, I didn't report it because I didn't think anybody would believe me. I dealt with it pretty well as far as things go, right until I didn't. When it came to the surface for me, I had to deal with unresolved trauma and the compounding issue of sitting in this body and realizing that my perception as a 20-year-old that I wouldn't be taken seriously was far too true. It wasn't pretty, and I'm a pretty well-adjusted adult with supportive family, a strong church community, and resources to deal with the belated fallout. Not everybody in that situation has that kind of support. We can count the costs in the kit that the state may need to provide, but it hides a far deeper cost. What is the cost of a survivor who knew that the state doesn't care about her rape, or how she fought off her attacker looking for comfort at the bottom of a glass, bottom of a bottle? What's the cost if she accepts that her role is to be quiet about rape and stays with the wrong guy who then abuses their kids? And this isn't just women. I heard from a man who was anally raped and was denied collection because he was told that the anus is hostile to evidence. What is the cost when he, after being turned away, swallows a bottle of pills or a bullet? I see this bill as a simple clarification of existing rights under law and a way to close the gap between what is written and what is implemented. With the concern demonstrated by agencies in charge of this process, I believe that the legislature should give clear guidance on this matter by passing this bill. $1,000 for a kit for a survivor is a drop in the bucket compared to the cost of not supporting a victim to the fullest extent that we can in those hours when it matters most. I urge your support, and I'm happy to take any questions.
I'm just going to ask you a general question, just based on a couple of, was it last year or 2 years ago? Mm-hmm. Other people who testified on the other side were saying that this is going to give rape victims a false sense of security, that they think they can do this test on their own. They're going to blow a chain of evidence, and they really need to be told that they really have to properly do it. And we want to convict the rapist. We want to have DNA evidence to link them to other crimes that they may have committed, so we get the guy who's a repeat offender off the street. So they made me a little skeptical in that I'm afraid, and I think I was a sponsor on the bill when I didn't understand it quite as well as I should, and I still am working on it. So am I giving someone a false sense of security? By giving them this kit when they really need to properly do it, to go to a hospital and have a trained personnel who's they're going to know how to use the rape kit properly. It'll be good for chain of custody for evidentiary reasons. Am I wrong in this whole part? Help me explain that to me better.
Well, thank you for the question. There are now at-home rape kits that you can purchase, but you can't purchase them in the state of New Hampshire.
Okay.
They're illegal here. What this does is that it makes sure that anybody who goes to the hospital or tells the police that they've been raped is made clear of their rights, and they know that they have the right to this exam. And quite frankly, if this doesn't pass, I'm expecting next year that if we can't ensure that the state makes sure that people get their rape kits, I'll put in to at least let them have that chance to try and get admissible evidence if they're denied a rape kit at the hospital. But I think it's far preferable, because state law already allows that and already provides for it, that we make it more clear so that the existing rights for the right chain of custody done correctly by sane nurses is something that happens, and we can start moving past this so that they're not victims, they're survivors.
Very good. Any questions, Senator? Nope. Senator Reardon, you're all set? Okay. Thank you very much for your testimony.
Thank you.
Introducing the bill.
And sorry that I'm not staying for the rest. I have some kids to feed.
I understand.
Thank you.
Jonah, I promised you two. And that's not trying to influence your DUI vote, right? It's a joke.
Don't worry, Senator, again. That's a totally different topic. I don't let those things
there you
bleed
go.
together.
Each one separate.
That's right. We don't do personalities. We bite on the text of the bill itself.
Okay.
Thank you, Chairman Gannon, members of the Senate Judiciary Committee. For the record, my name is Representative Jonah O'Ryan Wheeler, and I'm here as a co-sponsor of House Bill 1633. So I think Representative Leon just did a fantastic job, and I'm kind of restructuring my testimony as she really did a very powerful job, and I think illustrated very clearly why this is an important piece of legislation to make sure that people who are sexually assaulted, regardless of who they are, have their rights told to them and are fully understanding as to what avenues they have to seek justice for this crime that's been committed against them. I mean, I understand sort of that's what Pamela and I were talking about before I came up here, the sausage making process is never over. They left the definition of survivor broad, meaning, I mean, we were just talking about the fact that it doesn't exist in statute, and they prefer that. It's a broad way to apply survivor there. So as she said, as I'm committed to, I hope there's a way to figure out making sure that this text is perfect so that we get it back to the House. But the underlying merit of the bill, I think, is absolutely correct. I mean, I think the text of the bill is good. And I think that the fact that it passed both the policy committee, the finance committee of the House of Representatives, the policy committee unanimously, the finance committee with all but one, it passed the House floor twice, once unanimously on the consent calendar, and then another time with all but one, the same who was on finance, voting against the bill. I don't think you get that for almost any piece of legislation, but we got that for this one because telling sexual assault survivors their rights is something that everybody in this legislature can get behind. These are people going through the worst of the worst in their life, and the least that we can do is let them know what the law has available to them to seek justice. So I'll take any questions. I've followed this bill very closely, but I don't believe there will be any. And I hope we'll be able to find something that passes out of this committee that meets what everyone's looking for here to provide our sexual assault survivors with the rights that they need moving forward.
Thank you very much, Representative Wheeler.
Thank
We're
you,
all
Chairman
set.
Gannon, members of the committee.
Always good to see you.
You're too kind to me, Senator. You really are.
Representative Kelly Potenza. I tend to see you only when it's the evening's coming.
Thank you, Mr. Chair. I just have to ask, I have long testimony. It's probably about a good 10 minutes. I left my committee. I've been waiting here for almost 3 hours to testify. I mean, if you're going to cut me off, that's fine.
I'm going to give you 5.
All right, give me 5. So I'll have to figure out what I'm going to say, and then I'll send this to you as well.
The trick is not to read it. You just put it down and you just talk to us, and you'll be done in 5, and you'll get everything in.
It's too much information. So basically, I'm just gonna, for the
We're gonna
record,
read the testimony.
Representative Kelly Potenza, Stratford District 19. So my testimony is based upon the information that I believe that you have received. This is like second time around, as you might remember. This bill came through my first term, and so and all of the documents that the DOJ has sent, 282-page document, the letters, all of that. This is my testimony on it, refuting all of their information. So I'm going to start.
We're going to give them her 5 minutes.
So I want to address first the fiscal note that's attached to the bill directly, because this committee deserves an honest accounting of what it actually says and what it concedes. But just at its core, this bill is simple. It guarantees survivors are informed of their rights and ensures those rights are consistently delivered. It requires survivors to be told their rights and given clear written information. It ensures free access to exams and evidence collection. It guarantees long-term preservation of evidence up to 20 years. It requires notification before destruction of evidence. It mandates clear public-facing information from the DOJ so victims and the public understand the system. This is not expanding government power. This is not mandating unnecessary procedures. This is transparency in victim notification, period. These are not new laws. These laws, of course, already exist under New Hampshire law. This bill simply ensures survivors are actually told. So the DOJ's own numbers, this is what they admit. So you've already heard, right? They submitted a fiscal note totaling approximately $1 million. But look at where the numbers come from. The kit itself cost the DOJ $46.71. The large number, over $1 million, comes entirely from the DOJ's assumption that all 1,000 additional cases would require both a blood toxicology test and a urine toxicology test at $551 each. That's $1,102 in toxicology per case, assumed across the board. That assumption is not supported by clinical reality. Toxicology testing is indicated when drug-facilitated assault is suspected. Many sexual assault cases, particularly the less severe cases, the DOJ itself says are currently going without evidence collection, would not require both blood or urine testing. The DOJ's worst case assumption applied uniformly is what generates that number, not the actual projected cost of collecting evidence in these cases. But here's what matters most about this fiscal note. To generate even this inflated number, the Department of Justice had to officially state that 1,000 New Hampshire residents per year are presenting to covered providers as sexual assault victims, wanting evidence collected and not receiving it because no one told them they could ask. I want the committee to really sit with that number. The DOJ has put in writing 1,000 people per year are being turned away from their own rights in silence. And they submitted that fact as a reason to vote no on the bill that would fix it. That's not fiscal objection. That's an admission. So this is the hypocrisy in this bill. The DOJ says there's no data showing a problem. You can't claim a system works if victims don't know their rights. They say there's no problem. That's actually the problem. If victims don't know their rights, they don't report violations. If they don't report, you get no data. Then the state says no problem exists. That's literally circular logic used to justify inaction. The DOJ's own fiscal assumptions confirms the opposite. This problem exists at scale. This bill doesn't force anything about medical procedures. It's pretty clear that doctors have, of course, they have some clinical discretion here. But this whole Survivors Bill of Rights is already covered. Under RSA 21M, these are all things that are already covered. The legal error in the DOJ's argument is truly about this whole clinical discretion. So that doesn't force a kit to be used. It doesn't override medical judgment. It doesn't require evidence collection outside of best practices. It basically ensures that a victim can access what already exists. I'm going to go into DOJ is arguing against transparency. So this bill requires the DOJ to post clear information, explain evidence collection timelines, inform survivors of key evidentiary facts. DOJ calls that impractical. Informing victims of their rights is not impractical. It is the bare minimum. If the system depends on victims not knowing their rights, that is not a system worth defending. And I'm just going to get right to the point of this because this is what bothers me the most about all of this kind of stuff. This exposes a huge, deeper problem in New Hampshire. Let's just say it plainly. We aggressively prosecute drug offenses. I can tell you people that are in jail for 15 and 20 years for a drug offense. Yet with a sexual assault victim, you've got underreporting, you've got weak follow-through, and you have light sentencing outcomes. That creates a total two-tier justice system. You have a rape victim, and it gets prosecuted, and that person's in jail for 3 months, and they dumb it down. I mean, this bill helps basically correct that imbalance, which has been going on in New Hampshire for a very, very long time. I'm gonna end with pretty much exactly what Representative Jonah said. Representative Wheeler said, Criminal Justice Committee 12-0, Finance Committee 24-1, Full House Committee 341. That's not partisan, that's not accidental, that is a clear signal that this is common sense, victim-centered policy, and I just can't believe that this didn't pass first time around.
Questions?
I'll send you my testimony, just so you can have it. It's got a lot of other information in there. And then there's actually 3 little minor fixes that I think that could be made to the bill that will make it even better for you guys to pass this. So just a couple little word changes that I think can be helpful for you as well.
So just help me along a little bit. So one of my daughters is raped, okay? She gets a sexual assault kit from you. Can't face going in or whatever to a hospital. So she's doing this. How good is that kit going to be? She does it herself. She puts it in a freezer or something. Is that going to be admissible?
That is not, I can't answer that question. There's other people that can. I'm not a co-sponsor on this bill. The whole point of this bill that I want to pass is because I want victims to be informed of their rights. That's the most important thing. I want them, so for example, in all of these cases, that's automatically happening. In any sort of egregious sexual assault, rape case, that's happening. But if someone gets away, if you're getting attacked and you get away, and let's say you grab the person, you could have skin under your nails and all of that kind of stuff, that is the kind of stuff right now, people that are assaulted, but it's not intense. Those are the ones that are not getting, they're not getting told what they need. And that's the piece here. That's the disconnect. For egregious cases, I don't believe that we have an issue here. It's for other ones. It's for, and there's going to be other testimony that's going to speak to this, I believe, as well.
Okay.
But that's the problem here.
I'm good. Thank you, Kelly. Have a good night. Thank you, Representative. Representative Henry, and now I think it's a Giason? Guys, okay. We're getting, now I know it's an I and not an L, so we're almost there.
Thank you, Mr. Chair, Honorable Committee. For record, Representative Henry Geisen, Hillsborough 29th District, Goffstown, in support of this bill. So I'm kind of surprised that this was an issue of notification at all. And then when I looked at the fiscal note, to echo what my peer just said, the increase in fiscal note for maintaining evidence, I don't know why we wouldn't. But with all that said, I want to talk at this professionally for a minute. So in my 24-year career in the military, I served in additional duties as a sexual harassment and rape prevention officer, a victim advocate for victims of sexual assault, a suicide intervention officer, and a resiliency trainer. And the reason I list those last two things is because they go into play here. Now, in the military, if you have a victim or somebody that is claiming victimhood, the very first thing you would do is inform them of their rights. And if you're not a mandated reporter, then you can tell them of their right to, seek justice, or if they want to keep it private, you tell them their rights, you tell them their resources, you make sure that they understand that there's a counseling plan, you make sure that they understand that they can do a kit, you make sure that they have these resources so that they can go on, whether it's through due process of law to prosecute somebody, or whether it's they don't want to report and they want it all private, but they want to recover on their own. You give them the resources to heal and recover. If we're not giving our citizens those very resources on first touch, we are doing a disservice to them, and we are putting the lives of our citizens at risk, because it's demonstrated that victims of sexual assault and sexual violence are astronomically higher for chemical dependency, alcoholism, and suicidal ideation and suicidal completion. We need to be on the front of providing this information to potential victims. And I have firsthand knowledge of what being a victim goes through, and I have firsthand knowledge of what surviving through a false accusation means. And either way, what we need to do is we need to front load all of the information to every person who is a potential victim so that they can get the care. And I'm not worried if there's an expense to maintaining evidence. What I am worried about is giving our victims and our citizens the maximum information so that they can heal and become recovered, productive citizens in society and not statistics. Thank you.
Thank you. And maybe, again, my same question, maybe it isn't relevant, maybe I'm off. I'm afraid I'm giving one of my daughters a false sense of security, and she may be doing the totally wrong thing by not going to a hospital. I don't know if that, other people may tell me later, that's fine, that it's, that kit won't be admissible. And I want to get the guy who did it. I want to have his DNA to know that he raped 5 people in New Hampshire. And I'm afraid if she's doing it and she doesn't follow a chain of custody, but you're going to testify later, and maybe other people are shaking their heads. But that's what I'm fearful of, and I'm sure these other people are going to appease my fears in the upcoming testimony. So I'm all set. Thank you.
Was that a question or?
It was going to be a question, but I
dismissal.
had so many people shaking their heads. So
Okay.
I'll let them explain it to me.
My advice to you would be to take your daughter to a hospital and call the police.
Thank you. I'm getting there. Jade Blood? Flag, I'm sorry. Good evening, ma'am. Sorry to keep you here so late. And then just press the button and it'll go red on you.
Okay.
You're good to go. Just tell us who you are.
Hi,
Hi.
my name is Jade, and I'm here to talk about why this is important. A little bit of clarification on this over-the-counter stuff. It clearly states in the language that this would require covered providers to follow this.
Okay.
So home collection
Gotcha.
stuff, I don't know. Okay.
Okay, thank you.
So I'm here today to encourage you guys to consider and pass this bill. As a personal survivor of sexual assault and violence starting at the age of 6, I want to talk to you guys about what it actually means to make important, life-changing, and logical decisions after a giant trauma like that. You're in shock. You don't know what happened. Oftentimes, these are intimate partners and people you trust. If you are in a position to get to a hospital or a covered provider, you should absolutely be given every option you have to resolve this and seek justice for yourself. At that time, your brain is not online. You are in fight or flight. You are in a trauma response. You don't know what's going on. Your brain is trying to protect you from what actually just happened. So for a victim to come in and for a medical provider to be the only person to use discretion on whether or not evidence should be collected is insane. It should be given to the victims. If the victims have family, friends, any sort of support, everybody needs to know. I'm very, very confused about the resistance to something like this. Is it a money thing? Is it a fiscal thing? I mean, like, why are we denying people who are going through these horrific traumas a card that tells them their rights and what they can do moving forward? Because I can tell you, as a 39-year-old woman, I am still processing and dealing with the trauma and complex PTSD from all of my history. And if somebody had just been like, hey, this wasn't okay, you have rights, these are it, let's sit down, let's get you stable, let's get you back to a place where you can think, what comes next? What comes next for you? How does this fix this for you? How do you not live a lifetime of trauma and misery, hating yourself? Because, like everybody else said, suicidal ideation, suicidal completion, all of this absolutely linked to this for not knowing what to do. The definition of trauma is an event where your brain is confused and cannot make sense of what happened. Why not give victims a chance to figure out what happened and move forward? Anyway, rights only work when you need them the most. We don't know what we don't know, and in those moments, those survivors are not thinking about, oh my God, how do I, get this guy to go to jail? How do I get money out of this? How do I sue him? No. Their life is ending. Something horrific happened, and just it seems just very, very sad that we have to come out here, talk about our own traumas in order to prevent other people from going through what we did. When all somebody could have said was, hey, you have options to deal with this. You don't have to keep quiet. And that's all. Any
Very
questions?
good. Thank you for your testimony.
Thank you.
Okay, thank you. Esther Claudette? Good evening, ma'am.
Good evening. Hello, you all. Thank you for having me here. My name's Esther. I'm a middle school student here in Concord and a sexual assault awareness advocate. I'm here because this bill matters to the community and I want this committee to understand why. New Hampshire law already gives sexual assault survivors specific rights: the right to have forensic evidence collected, the right to a medical examination, the right to information about their options. These rights exist right now for every survivor in this state. But here's the problem. If a survivor doesn't know that these rights exist, they can't exercise them. A right that is kept secret is not a right. It's a promise that's undelivered. I want to ask this committee a question I ask everyone when I explain this bill. What does a right mean if it's kept secret? It means nothing. It's simply performative. It's just written there to show that you think that you support this, but you really don't. In school, we teach constitutional laws, the basic Bill of Rights, but we're not taught this. So this bill is here to let people know what to do. It does one thing. It requires covered providers to hand survivors a card listing the rights they already are entitled to under existing New Hampshire law. That's the entire bill. A card listing rights that already exist. When someone is arrested in this country, law enforcement must read them their rights. Not because those rights don't exist without being spoken out loud, but because rights only function when the person who holds them knows that they have them. I think that's common sense, because if you don't know you have a right, how are you going to exercise it if you just simply don't know? Survivors deserve at least the same basic courtesy we extend to the people who harm them. I've spoken to teachers, admin, my peers, survivors of sexual assault about this bill. As I explain it, the reaction is pretty much the same throughout. They assume that it is already the law. They can't imagine that a hospital would treat a sexual assault survivor and not tell them that they are legally entitled to a rape kit. It's absurd to them. It's seen as common sense. They're under the impression that it's simply well known. They are entitled to the right to be surprised because it should already be the law. That's why I'm asking you to make it one. I'm asking this committee to pass HB1633. The rights are already there. I just need you guys to tell people that they have them. It's the basic level of respect that everyone in this room and survivors of sexual assault deserve. I'm open to questions and I'll answer them the best I can.
Thank you for coming in. No questions? We're good.
Thank you
very
so
much.
much.
Appreciate it. Stacy Brown.
Hi, thank you. Good evening, members of the committee. Thank you for the opportunity to testify in strong support of House Bill 1633. My name is Stacy Brown. I'm a resident of Concord, and I serve on the City Council, though my testimony is my own and not on behalf of my ward or the City Council. Powerlessness protects predators. House Bill 1633 empowers victims by ensuring every survivor receives clear written notice of their rights. No more being left in the dark, no more systems that silence people. When I was not yet 21, I was at a party in an unfamiliar place and feeling awkward. I consumed too much alcohol and passed out. I came to while being assaulted. I was ashamed. I couldn't tell my parents. When I told friends, they didn't believe me. The Survivor's Bill of Rights would have been immensely helpful. Knowing I had the right to an evidence collection kit, one that would have proven what happened, would have made a huge difference. That simple information could have changed everything for me. As a counselor, I've heard far too many stories. Victims reach out for support only to be denied. If survivors knew their rights, they could have demanded the help they deserved, proof with forensic evidence, instead of being turned away. That is why this bill matters. HB 1633 puts power back where it belongs, with victims. New Hampshire's Survivor's Bill of Rights wasn't available when I needed it, but it's here now, and it entitles sexual assault survivors to specific protections under the law. HB 1633 only requires that survivors be told that they receive a card telling them that those rights exist. The provider can ask the patient to sign that they received it. We cannot allow predators and their enablers to keep victims powerless. House Bill 1633 is a straightforward, common sense step to inform survivors of their rights they already have. And I also want to point out that the organizations that have historically opposed this bill have registered as neutral. Actions speak louder than words, and out of 341 House members, 340 are proud to support a bill that protects and empowers survivors. I encourage you to please pass House Bill 1633. Thank you.
Thank you for your testimony. Dana Albright, are you still here? Good evening.
Good evening, Senator Dana Albrecht. You heard me earlier on the other bill supporting the coalitions and domestic survivors, and I'm here to do support of survivors again. I hope we can all agree that rape is a serious crime that should be prosecuted. I hope we can all agree that attempted rape under RSA 629(1) is also a serious crime that should be prosecuted. And since 1966, we've had Miranda v. Arizona, where if someone is arrested as a criminal defendant, they are read their due process rights, that they have a right to an attorney, a right to remain silent. And that's a wonderful thing. I believe in due process. I have to ask why 60 years later, in 2026, if a rape victim goes to a hospital, they are not told what their rights are under the law. And excuse me, I meant to pass this out. To directly address your question, Senator, you mentioned your daughter. I have daughters also. To get a rape kit in the first place, they would need to go to the hospital. Nobody's suggesting do-it-yourself evidence chains. I just would want my daughter, if she went to the hospital, all I want is for her to know what this statute says in simplified form. And if we're arguing that our citizens, especially victims, shouldn't even know what the current law says, that's a problem. And as it was pointed out earlier, this passed the other body 340 to 1. And I suppose you can always find some lone person to come up with some, I'm going to say lies, damned lies, or statistics. The lie, Mark Twain, Benjamin Disraeli, doesn't matter. Lies, damned lies, or statistics. The lie is that we shouldn't prosecute rape or attempted rape. The damned lie is that we shouldn't even tell victims what the law says. That's all we're asking here. And as for the statistics, you heard statistics earlier. And that's about all I have to say. But I'm happy to take questions. Thank you for your consideration.
Thank you very much. We're all set, I think. Very good. Francesca Potenza. Definitely know your mother's daughter.
I know, I think that's my mom over there. I don't know. Hi, my name is Francesca, and I'm a survivor of multiple sexual assaults. I want to offer this committee a straightforward way of thinking about what we already actually are deciding today. In the United States, when a person is arrested on suspicion of a crime, law enforcement is required by law to inform them of their rights. The right to remain silent, the right to an attorney, we call these Miranda rights. They exist in the Constitution whether or not they are read aloud, but we require that they be read aloud because we understand that a right a person does not know they have is not a right they can exercise. And we extend this protection to the person accused of the crime. HB 1633 asks that we extend the same basic courtesy to the person the crime was committed against. The Survivor's Bill of Rights is already New Hampshire law. It already entitles survivors to forensic evidence collection, medical examination, and information about their options. HB 1633 requires that covered providers hand survivors a card that tells them those rights exist. That is the whole bill. I've watched rights exist on a paper for a few years without reliably reaching to the people they were meant to protect. A right that is never communicated functions only for those who already know the system well enough to ask the right questions. That is not equal protection under the law. That is access to rights distributed by social capital and circumstances. This bill corrects that in the simplest possible way. It does not impose significant burdens on providers. It does not change the underlying law. It requires that the law be communicated to the person it was written to protect. Sexual assault is the most underreported and most underprosecuted violent crime. Only 5 out of every 1,000 perpetrators will end up in prison. Sexual violence costs the survivor and the state over $122,000 over the course of a lifetime in health care, lost wages, and long-term trauma for each person. Better evidence collection leads to stronger prosecutions, identifies serial offenders, and reduces repeat harm. The cost of doing nothing is not zero. Handing someone a card is the least structural barrier imaginable. It is almost nothing to ask, and it means everything to the person receiving it. And I'm just asking this committee to pass this bill. Survivors deserve to know what the law already says belongs to them.
Thank you very much for coming in today.